Good morning, friends. Once again, your President Raghavinder Das is back, and the topic is same. This is the subpart of my earlier video where we were discussing the Journal Land Register. Okay, I must, before I start, there has been absolutely no response, no message, no write-up, no feedback on what I spoke in my first GLR topic. I just want to know whether people are understanding who are watching my videos, because it's very important. I am educating people on something which nobody on earth, or whether in India in the last 70 years or maybe 100 years, has spoken of. These are facts what I am talking. I am talking law. I am not talking anything which is historical. I am talking which is in the rule books, in the laws written by the British. So friends, I once again request you, watch my videos, listen to them, make your notes, ask me questions. I'm always available. Very honestly, I have given my number on the channel itself. So now let's begin. I will rebrush your memories very fast. If you remember, we had seen two documents yesterday. One was an extract. I'll show it again to you. This is the extract. The other document what we saw was the full volume GLR. I today would say this GLR which you are seeing is my GLR of 102 Bungalow. If you see the remark column in this GLR, it very clearly says there are no record of terms of grant, and even then my bungalow on an admission deed is taken over as an old grant. So please friends, it is very important. Let's keep our mind together. Let us unite. Let us talk. Let's forget that egoism and jingoism between us. Let us be more honest. Let's open up. Nobody's properties documents is changing, whether it is in Mau Cantonment, Secunderabad, Ambala, Barakpur. Everybody's GLR speaks what I am saying, what I speak. I have all GLRs of 57 cantonments in my custody, which will gradually be seen on my website. Now we'll talk of where we left the last video. These are the columns. These are 13 columns. Now we will understand why these columns were given their descriptions or their names. Column 1 speaks of details and date of mutation and initial of military state officer. What is it speaking? Try and understand this language. It speaks of a simple mutation which has to take place. And when every mutation takes place, the MEO has to give a sign on it. He accepts that mutation. That means he is accepting the transfer. Now, where is he writing that this transfer is through the Commander-in-Chief by the permission of the Government of India? Nowhere. So please understand, where is this rule where it is written where the MEO or the present DO has to sign on my mutation register a transfer? It's written in these rule books itself. Let's go to column 2. It talks of subsidiary survey number. Why is it talking of a subsidiary survey number? It could have only talked of survey number. A subsidiary survey number simply in English would mean whether my grant has been subdivided, whether the government has taken up my grant in part. What has happened? The GGO says grant is undivisible. What are we? Aren't we mixing up too much things? Yes, this is where we need to understand. Have I taken a lease under the Cantonment Code 1889 of my old grant? Then my subsidiary number comes as a survey number. Whether it is in Cantonment Code 1889 or 1912, if I have converted my old grant or grant into lease to get my documentation done, this is where I would get a new survey number. Friends, I would like to share what is this survey number. This was originally given by a name by Captain Fenton, who did the first survey in 1822. These were called cadastral survey numbers. It's a lengthy discussion if we go into the surveys of India, which we'll do later in my coming videos. I'll just equate you what is a cadastral survey number and you will understand it very easily. If anybody is holding a property outside the cantonment or outside the urbanization of the township, you have villages, you have a khasra number. A khasra number can never change. All what a patwari would do is, he would add a numeric ~1, ~2 or whatever the division is. But the original khasra number remains the same. So there is no subsidiary of a khasra number. There is no change of a survey number. So friends, we need to understand, why is my survey number being given a subsidiary survey number? Column 3 speaks of volume and page of register. What is this? It says, where is this present entry coming? Which is the register? Which is the page number from where the MEO or the cantonment magistrate or the authority is picking up this entry, on which it is relying upon that I or my predecessors sold this property as a grant to me under the Governor General Order, whether 1836, 1827 or 1838. That's a debatable question. Friends, you will be surprised. Where are these old registers lying? Before the 1836 Bible of Governor General Order, which is imposed on us, in 1833 the Governor General Order said there will be an house property register of every property within the cantonment boundary pillar. Now, whether it was a grant, whether it was a freehold property on proprietary right, is again a subjective matter. So we need to know what and how this GLR speaks. You'll be surprised, I'll just tell you one thing. This General Land Register is actually the revenue record which a patwari of a village is holding on. Isn't it very surprising? So that means an MEO or a patwari is holding the same job. So that's it. Now column 4 speaks of area in acres or in square feet. It never speaks of dimensions, 100 into 120 or 400 feet into 200 feet. It only talks of below half an acre, above half an or a 1 acre. Why are these discrepancies in these columns? Column 5 speaks of description. This is giving an estate number to me. Friends, these estate numbers, when were given in 1938, I would prove had changed. These change dates could be 1889, 1912 or 1924, the Cantonment Act, or when the record of rights for your individual cantonments were being prepared. I would believe that my bungalow, I am taking the onus on myself, that my bungalow was given a state number called 102, the Mal Ambala Can. In 1870, I fished out a record, a sale deed by the Cantonment Magistrate Ambala, which says that my estate is holding a number called 266, the Mal Ambala Can. Friends, this is amazing. So why did the Britishers change the house property number? We people know our identities by the house number. We people would be surprised house numbers changed, but our survey numbers never changed. You must see to this. Now when we move to the next thing, column 6, it speaks of class. Now what is this class? There were 3 types of class. A meant army, B meant bungalows, C meant cantonments. We were in 1937 subjected to B3. Now in B3 also you have B1, B2, B3. Similar you have in A and C also. We're not going into that. What was the class before 1937? Was I B? There was a CLA rules, if most of the people know, 1925. Was I in 1925 also called B3 lands? Again, it is a matter to be discussed and subjected, which we'll be discussing in our coming videos. Column 7, who managed my land? Prior to 1937 or 1924, all lands were being managed by the Cantonment Magistrate, whom we may call Cantonment Authority, or the present CEO, that is the Cantonment Executive Officer. The MU was only a patwari or a record keeper stated in the cantonment laws. So the lands were never maintained by the MU or the DO. They were maintained only and only by the cantonment authority. So when did this notification shift from cantonment magistrate to military state officer? Is again a debatable question. We need to understand that the MU was always given an instructed power of a patwari, a land record keeper. What is a patwari? In English, you convert is a land record keeper. So friends, please understand all this. Column 8 talks of landlord, a very disputable subject. The MU shockingly has put this into a very different tone. He has placed my estate in B3 lands first. And if you people read the B3 land definition, it is a very twisted language. It says by some executive order prior to the 1937-1925 rules. Why is it talking of an executive order? Instead, we've been always told that Governor General orders were law, were statutory orders. So why is it talking of an executive order? That means GGO was never a law. It was an executive order. You will be shocked what B3 language is in 1925, how the cantonment magistrate was asked to draft the definition of B3. He was even asked that if anybody disputed of his property or estate being placed in B3, the cantonment magistrate would file a suit against him, and if proved in court that this is government land, he would yet place the property in B3 land. Why? Once it is proved that I am a government land, it should have been subjected to Class A or Class C. Why was I brought back into B3? This is where I keep saying to most of my people in my videos, the Britishers were law-abiding. They knew they could not do something which was breaking the law. The Queen of England would have questioned their integrity. So they, even after a court case, even after being proved it is a government land, they said we will subject you to B3 only. This is very important to understand why we were kept in B3, why we were not taken in any other class. So what really happened in 1937 and how we were subjected to all this? The two conditions which influxed in 1937 CLA rules were that we will be subjected to B3 lands, one, and second, that all of us will give an admission deed under Rule 43 or 47, that this land belongs to government. Now, it never spoke of whether which GGO, but it spoke of it was government land. Column 9 speaks of holder of occupancy right. Now, what are this holder of occupancy right, or let's say an HOR? These are defined under the Land Revenue Acts made for different states in India. You would mostly know that every state, which were the 5 territories in India of the British divided India or the even amalgamated India, were the Punjab, Agra province or the Bengal province or the Madras, they had all their own individual revenue acts. Like we had Punjab Land Revenue Act 1857. This very clearly said that an HOR is a true owner of his estate. How is it? Was under a Punjab tenancy law or an occupancy. So this is again a subject where we will be talking in length, which we'll do it later. Now column 10 of the GLR is saying nature of holder's right. This only speaks of old grant. I am surprised. In 1938, the British officer or the MEO then or the cantonment magistrate was a British officer. He could have very easily written, instead of old grant, GGO 179 or GGO 260 of 1838 or GGO 14 of 1827. Why did he even then also write old grant only? Because at that time also there was suspicion whether I am a grant under A, B, C, D or that n number of GGOs passed. Column 11 speaks of what? Rent payable. Nowhere these GGOs, if most of you people have seen, which I am mentioning, speaks of any rent to be paid to the government by the HOR or by the grantee. So when was this rent influxed? This rent was influxed when in 1889, I volunteered and converted my old grant into a lease in perpetuity or in conditionality. I was asked to pay up some money so that my documentations could be done. And this is where I was paying rent, whether to central government if the grant was converted by the central government, and if that grant was converted by the cantonment magistrate, it was to the cantonment magistrate. But please understand, prior to 1938, there were no civil areas. So everything was under the cantonment magistrate. Now the column 12 speaks of that expiry of my lease. Now when it is expiring, in most of the cases where it is old grant, this is left blank. Whether it is a lease property, the dates are mentioned. The last column speaks of remarks. Friends, go back and see my GLR. If you want, I can show it again to you, the full volume. What does this remark column say? Where this GLR is coming, it will only speak of one line entry that granted to Mrs. A. Jennings in 1848. Which order, which section, where are those documents? They all become very suspicious. And it's very easy to say these are vernacular records. Not available, not traceable. Land records have been documented by the Britishers, can never be lost, and it is the duty of the cantonment magistrate to keep them safely in safe custody. Now this remark column speaks of one very interesting column and statement written, that is when my predecessor or me signed an admission deed, whether it was registered or it was under the TP Act, it is talking of that. Otherwise it talks of nothing. Doesn't speak of GGO, doesn't speak of anything. So friends, these 13 columns are very important. My discussion in coming video would be on GLR of 1925. I'm grateful that you've been listening to me, and I expect you to respond back to me after going through this. Thank you. Good day.